global transparency landscape. First of all, what we see is that we have two different bases for disclosure. First one is we have laws, international disclosure laws, and this we find in Denmark, Estonia, France, Greece, Hungary, Philippines, Portugal, Romania, Slovakia, and Turkey. And next to this, we have countries which have sometimes additionally, sometimes solely, only disclosure codes. And these are of course, the 33 EFPIA member countries. They are bound by the codes. Then we have Australia, Iceland, Japan, and Luxembourg. If you have a look at the map, you can see that we have many countries which have laws on the one hand. We have countries which have only industry codes on the other hand. And we have countries which are bound by both the codes and the laws. And now I may shift over to Elizabeth Kotek, who will walk you through the details.
Thank you. So what are the differences between laws and industry codes? Well, laws generally apply to marketing authorization holders, entities operating in a specific country, and/or entities providing benefits or other transfers of value to healthcare professionals from the country. The scope of reporting entities and covered recipients tends to be broader than with industry codes, and they are enforced by government authorities and often carry more severe penalties. Industry codes generally bind only those member companies and entities that voluntarily choose to be bound by that code, and they are enforced by the industry association itself and often require severe breaches to trigger monetary penalties. Please be aware that the data privacy regulations and content concerns generally apply to all actions. It doesn't matter whether they are under laws or industry codes, but we will get to that point later again. So the EFPIA disclosure code is the disclosure code of the European Federation of Pharmaceutical Industry Associations, and EFPIA is the umbrella pharmaceutical trade organization in the European Union. It brings together 33 European national pharmaceutical industry associations, as well as 41 leading companies undertaking research, development, and the manufacture in Europe of medicinal products for human use. The EFPIA Disclosure Code was approved in June 2014, and its requirements were transposed into each member association country code. There is significant uniformity between countries, but some areas of variation. For example, disclosure language, disclosure platform, and consent requirements. The tracking of transfers of value was required to begin on January 1st in 2015, and the first reports were just due by June 30 in 2016, either on the member website or on a central web platform. This depends on the national code. The basic requirements of the EFPIA disclosure code is to track and disclose transfer of value, which is the direct or indirect benefit in cash or kind provided for promotional or other purpose made to healthcare professionals and HCOs. A healthcare professional is defined to include European members of the medical, dental, pharmacy, or nursing professions, or any other person who, in the course of his or her professional activities, may prescribe, purchase, supply, recommend, or administer a medicinal product. A healthcare organization is any legal person in Europe that is a healthcare, medical, or scientific association or organization, for example, a hospital or a learned society, or through which one or more healthcare professionals provide services. Please be aware that some member associations in some countries have altered the definition of healthcare professional to include also additional recipients, for example, midwives or paramedics. So when reviewing whether the person you're cooperating with is a healthcare professional, you always have to take care or take in mind the very national regulations and the national definitions of healthcare professionals. The EFPIA disclosure code provides specific reporting categories for healthcare professionals, which covers cost contributions for events and fees for service and consulting. And for healthcare organizations, it's donations or grants, cost contributions for events, and fees for service and consultancy. Research and development transfer of value must be disclosed in the aggregate. There are also some exemptions which we listed here, which would be OTC drugs solely involved in transfers of value, items not listed in the code, for example, items of medical utility, meals, drinks, samples, and ordinary course purchases and sales of medicinal products. When assessing the disclosure obligations, you always must review the specific obligations of the respective country you are operating in. For each country, a different set of rules applies that must be taken into consideration. So what we want to do now is to give you a basic overview of some country-specific considerations you should be aware of. First, the country considerations for Denmark. So the disclosure obligations in Denmark stem from Danish law. There's unique that in many of the reporting obligations are placed on the HCP himself. The manufacturers have a duty to ensure that HCPs comply with their obligations. The manufacturers must notify and receive permission from the Danish Health and Medicines Authority anytime a doctor, dentist, or pharmacist becomes associated with the manufacturer, and the manufacturer must provide the DHMA and publish on their own website a list of HCPs and organizations with which they collaborate. In France, the disclosure obligations also stem from French law. Manufacturers must report all benefits in cash or in kind with a value of 10 euros, tax included, or more, provided directly or indirectly to covered recipients, as well as any agreements with covered recipients. In Germany, the disclosure obligations stem from the industry code. It's the FSA Transparency Code, and it applies only to the member companies of the FSA. FSA is a member of EFPIA, and the disclosure requirements mirror those requirements of EFPIA. Pharmaceutical manufacturers must disclose irrelevant transfers of value in connection with training events, which would be registration fees, travel and accommodation expenses, as well as fees for service and consultancy. In the Netherlands, the disclosure obligations also stem from a code of conduct, which is a CGR code of conduct, and applies to a broad spectrum of industry associations, including innovative pharmaceuticals, generic pharmaceuticals, self-care medicines, physicians, pharmacists, nurses, physician assistants, and druggists. The pharmaceutical manufacturers must disclose all financial arrangements with HCPs that are worth more than 500 euros per year. The report must be submitted annually to the CGR Central Register by March 31st. And NIPHARMA, the Dutch Pharmaceutical Industry Association, receives an exemption from EFPIA with regard to the disclosure code. NIPHARMA members must follow the CGR code disclosure requirements solely. In the UK, the disclosure obligations also stem from the industry code. It's the ABPY Code of Practice, and it applies only to member companies. Pharmaceutical manufacturers there must disclose in relevant parts transfers of value in connection with training events and fees for service and consultancy. As already mentioned before, when disclosing transfer of values, the pharmaceutical companies must always observe data privacy laws. So So we want to shed some light on that. In the European Union, the restrictions on processing of personal data follow from Directive 95/46/EC on the protection of individuals with regard to the processing of personal data. The directive protects any personal data of natural persons, and personal data is defined as any information relating to an identified or identifiable natural person. And such personal data of HCPs may be disclosed only if the HCP has given unambiguously his consent, or disclosure is necessary for compliance with the legal obligation to which the controller is subject. This means that in member states where disclosing is not a legal obligation, companies must seek the unambiguous consent of the HCP prior to publishing personal data. So you may not just disclose the personal data without having prior consent. The consent must be based on the HCP's free decision. It must be fully informed about the purpose, type, and scope of publication, and it must in general be in writing. The member states transposed the regulations from Directive 95/46/EC into national data protection laws. So each member state of the EU has its own data protection law, which must be reviewed and assessed prior to just disclosing personal data. When considering and disclosing transfers of value to healthcare professionals, you always must keep in mind that anti-corruption regulations of the specific countries you're operating in. We want to share with you now the situation in Germany, where we have a very new anti-corruption laws for the healthcare sector. The intention of the new law is to close the regulatory gap regarding the improper influence at the prescription, distribution, or administration decisions of healthcare professionals. Because in 2012, the Federal Supreme Court ruled that anti-corruption laws did not cover resident physicians or any other independent or employed HCP. So the German legislator introduced very recently a new criminal offense, which is taking and giving bribes in the healthcare sector, with new sections 299A and 299B of the German Criminal Code. They just entered into force on June 4th, 2016. Section 299A of the German Criminal Code is taking bribes in the healthcare sector, and it criminalizes any healthcare professional who is required to complete a state-regulated education for his professional practice or for the use of his professional title, and who then demands, allows himself to promise, or accepts a benefit for himself or another person at the exercise of his profession as consideration for providing an unfair preference in the 1. Prescription of medicinal products, remedies or tools of medical devices, purchase of medicinal products, remedies or tools or medical devices which are intended for direct use by the healthcare professional or his assistant, or the procurement of patients or examination of materials. And this action shall be liable to imprisonment of up to 3 years or a fine. Section 299B inversely criminalizes the pharmaceutical companies who are offering or providing such gifts or benefits to HCPs. And Section 300 foresees aggravated sentences in especially serious cases. So now we want to have a look on where the bottom line of bribery and this anti-corruption rules is. And I would like to hand over to Ulf.
Thank you, Elizabeth. You have walked us through the disclosure, consent, and bribery laws on a country level even. And now the question is, where's the bottom line of the corruption laws, which means what is allowed? All anti-corruption laws in the European Union are limited by European laws. The national anti-corruption laws, including the anti-bribery criminal laws, must comply with European law. National anti-corruption laws must not punish activities which are allowed by European law. In a nutshell, benefits granted to HCPs are admissible as long as they are not likely to improperly influence those HCPs. What is the legal background? We find some articles in the Directive 2001/83, which is the Directive on Pharmaceutical Products for Human Use, and in particular the articles 94, 95, 96, and so on are the relevant articles in this system. In particular, Article 94 provides that no benefits must be supplied, offered, or promised to HCPs qualified to prescribe or supply medicinal products unless, and this is important, unless they are inexpensive and relevant to the practice of medicines or pharmacy. This prohibition seeks to prevent promotional practices which may induce HCPs to act in accordance with their economic interests when prescribing or supplying medicinal products. This is what the European Court of Justice held in a case in 2010. And not only the European Court of Justice is bound by that, in addition, all courts in the European member states are also bound. And we see this in a case handled by the German Supreme Federal Court. Now, what are the practical considerations? On a high level, it's very important to assess potential and transparency and disclosure obligations associated with the interaction. And please keep in mind, transparency obligations can be based on law, industry code, or both. Data privacy and consent issues need to be considered as well. Of course, we have seen that the medal of transparency has two sides. One is transparency, and the second one is bribery. And that's the reason why you need to be aware of and sensitive to the application of the anti-bribery laws, including the US Foreign Corruption Practices Act, the UK Bribery Act, the directive, of course, I've mentioned, and the German Criminal Code. Comply with applicable local laws and regulations, comply with local trade association industry codes of associations, and that's important, of which your company is a member. Because only if your company is a member of these associations, then your company is directly bound. But also non-member companies should also consider the principles, because very often court holds that these are state-of-the-art. And of course, it's very important that you comply not only to policies and procedures which are being bound by the laws and codes. It's very important that you also comply with your own policy and procedures. What are the practical considerations when collaborating with HCPs? First of all, develop a real good process and protocol to help ensure that all relevant issues are considered when engaging HCPs. So the first practical question is, what is allowed to pay to an HCP? Is it allowed to pay the same amount to a director of a department of a hospital, or also to a junior doctor? In some countries, this could be the case. This really depends on country by country. But in many countries in which this will be held and seen very individually, it's probably the case that the director of a department of a hospital, so a professor, could be charged a bit more than a junior doctor. So it's very important to consider what kind of HCP shall be engaged. For this, it's very important to develop this kind of process and a protocol. Then, sensitize your colleagues to these issues to help avoid internal conflicts and confusion. And as a general matter, it would be good practice to document the legitimate purposes of why your company is engaging a particular HCP or covering travel, lodging, and registration registration fees for an HCP to attend an event. For particular events, consider the lowest common denominator, most respective approach to help avoid the need of implement varying value limits and other restrictions for each particular HCP at the event, depending on where he or she is from and licensed. Practical consideration to reduce the risk of prosecution is the final aspect. First of all, ensure that possible consent requirements are met, of course. Secondly, review all existing agreements with HCP and internal corporate directives and amend accordingly with view to the anti-corruption laws in the relevant countries. And then be aware of specific requirements for internal documentation. Publications relating to granted benefits may constitute the beginning of a suspicion that would justify initiating criminal proceedings. Thank you for listening so far for the legal part of the aspects. If you have any questions, you may address these via email. Now I ask Ned Munters from Cordata to tell us about the technical solutions for meeting all the requirements.
Why Ned is getting on, Tom Sullivan. I just want to let you guys know that if you're interested in asking questions, to enter them in the right-hand side of your box. Also, on your computer screen. Also, there have been several questions coming in, but we are getting your questions. So, Ned, if you can go ahead and start.
All right. Thank you, Tom. Thank you all. And Elizabeth, appreciate your guidance and session. So my name is Ned Mumtaz. I'm with Core Data. And what I intend to share with you today is compliance and risk management in the context of physician consent and data transparency, and particularly a pathway that helps manufacturers nurture their relationship and access to prescribers and physicians. So with that context, what I want to do is walk you through some of these capabilities and options. So first off, from a pharmaceutical compliance and risk management aspect, I take the position that pharmaceutical corporations are committed to doing business ethically. Corporations also know that compliance missteps could lead to regulatory and legal risks. And they also understand that the healthcare industry in particular and pharmaceutical industry in general operates in a highly regulated environment with a set of laws, guidelines, and regulations governing their operations. Few, however, I feel, can precisely know which specific aspect of regulation or business activity could trigger compliance challenges. So in that context, I feel that the best practices manufacturers have followed from a compliance standpoint is where their leaders anticipate risk and they protect against these risks. And again, in the context of consent management and data transparency, I intend to share some of those aspects of risk and approaches to manage against those risks. So EFPIA Transparency Directive and the risk of violating the data privacy laws. As far as the data privacy laws are concerned, we feel that the physician disclosure has been gaining momentum for several years. You heard that across North America, European Union, Asia Pacific, and even there's word around South America, the regulation and transparency directives are continuing to increase. And in that context, progressive compliance programs are focusing on partnering with HCPs and HCOs during this period of change, while I feel there are many who are just content in reporting on those spend transactions. Also in the context of risk, the risk of violating data privacy laws are severe and significant. Not that the risks of errors in disclosure are insignificant, but they are less intense as it stands today. Plus, there are other aspects which are non-financial risks, which are key and important to observe and focus. And those include loss of brand and company reputation, and especially loss of relationship and access to physician, which I will focus on in the next few minutes. And on that topic, what I want to do next is to help share and see the physician disclosure from HCPs and physicians' point of view, and help clarify why I feel that compliance leaders are beginning to focus on physician and physician disclosure. And I'll also try to share learnings from interactions Core Data has had with physicians and how manufacturers have an opportunity to better partner with the physician. So let's take the perspective and the point of view of a physician. And if we can role play for just a couple of minutes, imagine your name is Dr. Joe Klein, and you are a leading dermatologist in the country. You have kept up with the new procedures, therapies, diagnostic techniques, drug discoveries, and clinical trials. You have also helped patients get reimbursement for cutting-edge treatments and added new drugs to payer formularies. You are a voracious reader, a skilled author, an admired speaker, and a careful clinical investigator and a clinician. Your growing practice is attracting best physicians and even better clients. Pharmaceutical representatives wait days to see you. Your speaking engagements are booked months in advance, and you get the pick of clinical trial investigations of your choosing. And Dr. Klein has always done business ethically. He's very busy practicing medicine, and therefore he has paid limited attention to the transparency directives and has so far agreed to freely consent to pharmaceutical manufacturers to disclose payment. Now let's fast forward towards middle of Q3 2016 and again continue to look at things from Dr. Klein's point of view. So it's now Saturday, July 30th. Dr. Klein has taken notice of recent So Dr. Klein has taken notice of recent media noise claiming payments from pharmaceutical corporations to HCPs and HCOs, and there's serious business in EU where millions of euros are exchanging hands. So at this point, there are a few questions that are coming up for Dr. Klein to consider and be prepared to answer. Some of those questions are, how would the patients react in the coming months as this information becomes distributed broadly? Should Dr. Klein have consented to spend disclosure? Should he have inspected the disclosed spend? Should he have inspected reports before they were published? Could reporting errors create wrong judgment? Could he track, verify, and manage his consent status? And more. So in general, what we feel is that physicians may be nervous about the impact to their business from any negative publicity that the transparency produces, whether that negative publicity is real or inadvertent. But that's a point of nervousness for them. So given that, is there a path forward, and what can we expect from that path forward to a situation where the risk is managed both for the physician and the pharmaceutical manufacturer, and could we look for a win-win program? And while at it, I also want to point out that, as I mentioned a few minutes ago, there is a very direct and close link between data transparency and physicians' data privacy. And a lot of both industry as well as practitioners have been writing about it, and that's coming into fore lately. So in that context, let me summarize very quickly the 3 points I made. First one is that the compliance leaders anticipate risks, and they protect against these risks. We are seeing that progressive compliance executives are focusing on partnering with HCPs and HCOs during this period of change, while we feel others are just content with reporting spend. And on the flip side, from a physician standpoint, they are nervous about the impact to their business, and they want easy access to information being published. They want the ability to manage the accuracy of data being published, and they also want to manage privacy of their data. So what I want to take you to is share and express what we feel is the pathway to a win-win program. And what that win-win program might look like. Is there a path to better manage risk without compromising on physician relationship and access? We feel there is. We feel that organizations that focus on disclosure while paying attention to the HCP needs would be on this win-win path. And in the next couple of slides, what I'll share with you is what those programs might look like, what might be the elements and components of such a program, and I'll try to describe the vision of such a solution, both in words and pictures. So if a manufacturer were to partner with physicians and to manage both spend and consent, what are some of the best practices we could expect in such a program driven by the compliance management team? We feel such a program would have the ability to electronically track and report consent status every time, all the time, and be able to provide verifiable information around that consent, be able to electronically store consent, revocations, revisions, and denials. And I'll share with you the significance of electronic storage versus paper storage in the next slide. Provide easy access, and in fact, ideally 24/7 access to all stakeholders, including HCPs. Support verbal, phone, email, paper, digital, and online processes for collecting and managing consent. Maintain standard operating procedures that can attest to the above aspects. Update transparency reports across all countries immediately or as needed. And most importantly, meet data privacy, data security, and data recovery directives and laws. So next, what I'll share with you is a blueprint in terms of graphic representation of a physician consent management system that addresses the above. Okay. So in this illustration, what I would like to do is point to the center of the circle with the label consent database, and we feel that would be the focal point, the pivot that can help create the type of capability I just shared with you. In this vision, the consent database would receive consent in several different forms that's represented here. Paper documents will get recorded in a digitized format as PDF or any other mechanism that you so choose, with the image made available for as long as the manufacturer chooses to maintain it. The ability for the web portal represented on the top right to allow the physician to access the spend information and provide consent through the portal, as well as for the compliance management and admin to do the same in terms of updating the consent status and any changes received from the physician through any of the means or medium to update such a status. Thirdly, to provide a mobile application that's represented in the top left that reflects the ability to capture consent electronically, digitally on a mobile device such as an iPad or an iPhone or a tablet, where the sales rep or medical services liaison or CRO who comes in contact with an investigator or a physician can capture that consent at the point of contact. And all these different sources of input immediately update the consent database to provide that 24/7, every time, all the time, the current status of consent. Two more important aspects with respect to policy and consent language. In such a process, you can maintain and manage and update the consent language immediately, as well as apply the policy through these various points of consent capture. And then lastly, this consent would drive the publication of the spend report and transparency across multiple geographies. And that report can be produced again in any format you choose, whether it's PDF, image, or a website. And you can expect the general niceties of a system that is cloud-based, has the ability to securely maintain the information and certainly back up as well as handle disaster recovery so that your legal requirements for maintaining such an information for an extended period of time is fully supported. So this is just an illustrative vision of what such a solution might look like and help you maintain two key aspects that I started the discussion with. One is to manage your risk to ensure that your organization is not exposed to reporting spend without consent, or if there's any ambiguity about the status of consent. And secondly, to provide a mechanism where your physician partner has ability to see, review, and update consent at any point in time. In addition to it, have the ability to know what's being reported, to know what's being captured in terms of spend, and have access to it. So in summary, what I want to do next is just show you illustratively, and this is just a very brief illustration of what that central data content might contain. Here's an example of Core Pharma listing its various physicians, Dr. John Doe in Germany, whose total spend for the year 2015 is 3,000 euros, had given consent online, and that's captured. Another physician, Jim Khan, has given consent digitally by signing a mobile device. Dr. John Doe again had given paper consent, and so forth. So hopefully you get the picture that by providing multiple access points and multiple mediums for collecting consent, you give yourself the best chance and the best opportunity to partner with your physicians, as well as provide up to minute information to your organization. Based on our survey, conversations, and attendance of several conferences, we feel that manufacturers today, especially in EU, have gone through a pretty comprehensive process for collecting consent. And that collection is happening through paper as well as through digital medium. Manufacturers have also gone through the effort of modifying the contractual agreements to include the necessary language to collect physician consent. But we do feel there's a challenge today. And that challenge is in the manufacturer's current ability to handle changes, especially multiple changes to consent. Let's look at just a couple of examples. First example, the manufacturer reached out to the physician and the physician declined consent. In such a situation, no paper trail is really getting created. It's simply the case that the request sent, whether in paper or through other medium, was declined. So a system that's only capturing consent would not know the difference between the request for consent being declined versus the fact that there was no response received from the physician. Another scenario where the physician received the paper document but chose to send a note through email offering his or her consent. In this scenario, unless the email information can be captured in a central repository with such aspects as to the date when the consent was given, what items were consented, what spend was consented, etc., you have the risk that that email in an isolation would not give you the proper context. A third scenario, that a physician revokes consent in writing. This creates a challenge to go find the original consent and look at the relevant dates, especially if after revocation the consent is again approved. And then another challenging one where a physician verbally revokes consent as he or she meets with the sales representative or clinical trial manager, and there are others in the presence of whom the physician has expressed his intent or her intent to revoke the consent. What happens? How do you handle that in a paper-based system? So we feel that these are some of the challenges that the vision we shared might be able to address them very comfortably and amicably. So in summary and in final analysis, what we want to share is that in an ideal state, the solution should be designed to help educate the physician about the options they have in reviewing spend and providing consent, and make it very clear that the manufacturer is intent on both partnering with the physician and also providing ease of access to managing consent. Second aspect is that physician consent needs to be a precursor to any transparency reporting, and that needs to be managed with the criteria we laid out earlier, that the status of consent should be known to all stakeholders anytime and all the time. Third important aspect to it is that based on the changes to consent, the transparency report should be ready to be updated at the frequency of your choosing. There are certainly legal expectations in terms of how frequently and how quickly the report must be updated and the latest status of consent reflected in terms of the report details or summarization. But for that process to be effective, it must be nicely linked and attached to the consent status. And then lastly, a topic which we feel would be coming to the fore in the near future is the ability to provide the physician to either challenge, correct, or dispute any spend that's reported. And again, make that simple, easy, and designed to show a level of partnership with the physician stakeholders. So with that, I would look to see if there are any questions that we may address. And I appreciate you listening to our point of view on helping to manage physician consent. Thank you so much.
Thank you very much, Ned. And if you guys, and Ned, if you can turn off your speakers, because I'm not getting feedback, that'd be useful. Quick question for you: Is it legally required to collect consent paper in some EU countries, specifically Germany? And this is more for Ulf and Elizabeth. Do you have to have paper consent, or and specifically in Germany, or can you, or is online acceptable?
Well, in general, you need to have the consent in writing. That means you need to have it in paper. If you have a real signature, which is digital as well, and it's proven that this signature is not just a copy, but really made by the physician, then I think this should be sufficient as well. But indeed, it's not only required that a physician would provide you with a consent orally, because it's very important that there is the proof that the physician has really provided the consent. So it's a obligation towards the pharmaceutical company of who's conducting the service, who's engaging the HCP to conduct the services.
Another question here is around consent. If an HCP, first of all, if our company is required to provide a way for them to revoke consent, And then the second part of this question is, if HCP revokes consent, how long does the manufacturer company have to remove that spend data from the website or other publications?
If the physician is revoking his consent, then the manufacturer has to withdraw the activities and has to delete all aspects forever, as long as the physician is agreeing to the new publication. So it's very important that you keep this in mind. It's not a time aspect. It's really important that you really delete everything until the physician has changed his mind.
So does that mean that, so let's say I'm a company and I receive a request to revoke a consent. Do I have to do I have 30 days or 60 days or is there will I be pinged from the moment he says it, or I guess how long is there a kind of a knowledge about how long they reasonably give me to do this?
You need to remove it immediately. So if you have a technician who is able to do that, then you need to do this within a couple of hours.
Okay. Now, is it possible for a company to make a policy to only work with HCPs that provide consent?
Well, in general, yes. In general, it's possible. The question is whether this is wise from the business point of view and the scientific point of view. But in general, yes, it's possible.
Now you mentioned on the German laws and then the European laws, and it seemed like in the German laws, can you give some practical examples of what would be allowed under the German law, and then what may be a conflict between the German law and the European laws? Because you said that the European laws like override the German laws. Just some practical examples, I think, for the audience.
Well, I think it's very hard to provide you with a practical example because the German anti-bribery law is extremely new. So we don't have any judgment of this, obviously. But to provide you with an idea what where the limits are, when you have asked German politicians whether even very small items could fall under bribery, the politicians normally say, yes, we do not have de minimis rulings. That means all kinds of items may fall under bribery. And this is different under European laws. Under European laws, it is allowed to provide the HCP with unexpected items. And as long as these items are really unexpected, but the question is where the difference is or where the limit is. We normally see the limits with a value of €5. So if there's an item below €5, then there's probably no bribery under EU laws. But this could be different. This could be different seen under German laws. But once again, the German laws are bound by and limited by the EU laws. But indeed, there's it's a question which is not judged so far. There's no decision. So this is still in progress, and we need to see what happens. But it's very important to make sure that there's a real good documentation why a gift or why any positive aspect will not influence an HCP improperly.
Were there any exceptions to congresses or other meetings where a physician attends and receives some kind of a food on the floor of an exhibit hall, or or attends a dinner at a symposium? Will companies have to be very careful with that kind of thing?
Well, in general, scientific congresses shall be held, of course, so this should not be disturbed, but everything which is around that could be very difficult. So it's very hard to explain why you fly over a medical doctor first class. This is in particular if this could be an intercontinental flight. So this is very difficult to explain. This is probably falling under bribery. Same applies to the hotel. If you go to a 5-star plus hotel, then it's very hard to explain this to a judge why this kind of hotel has been chosen. If the HCP would be in the position to say, well, I'm flying only first class and I will not fly any other class, and I do this also privately, so this is my standard. This could be a kind of different, but of course it's very important to provide this evidence that this is going to happen, and you should definitely double check whether you want to invite the specific HCP. So it's very important to make sure that there is no real benefit seen on the HCP side. But indeed, this is something which is in progress now. We don't have judgments, but it's very important to have a good documentation, because this is what we learned from our talks to the criminal investigators, who are really waiting for the disclosure, and then they want to start how to investigate it. They want to elaborate what the limits are from their point of view.
Tom, real quick, there's a question that came in from Carly Hahn. The question is around HCP consent changes. And the question is there a cutoff date each year for HCPs to change their consent? Ulf, I would appreciate if you could address that question.
I don't know whether this question has been answered already. If an HCP is changing his mind and he is revoking his consent, then indeed the company has to remove all the data from the web page, as long as the transparency is related to a consent. If you have companies or countries in which the transparency is not related to a consent, so it could be that there's a country which says we want to have disclosure anyway without focusing on the consent, then it's a bit different, of course. But as long as there's a relation to the consent, the company has to remove everything after having learned that the consent has been revoked.
So an aspect to this question was around timing. So is there such a thing as a cutoff date each year to revoke consent, or could a physician revoke consent at any time?
At any time.
Okay. Thank you. Thank you for that clarification.
Well, we appreciate you guys. We're running a little out of time. We're running a little bit for the end of our time. Ned, if you had any final comments, and then Ulf, and then Elizabeth, just if you can each give us like a 20-second final comment, I'd appreciate it. So Ned?
Sure. So a quick comment from my side is that what I shared with you is just a vision. And if you are interested to understand more aspects to what I shared in summary, we'll be happy to provide you those details. And again, thank you so much for your time today. Appreciate it.
So Ulf?
Well, we have shared with you not that much a vision, more reality. It's very important to really check what kind of service the HCP shall conduct and what kind of fees he shall receive for that. So that's very important, because otherwise the company is running the risk of a criminal investigation. So transparency and the bribery aspect are in balance with each other, and it's very important to keep this in mind. And thank you very much for listening.
Okay, and Elizabeth, did you have any final comments, or are you good?
I just want to remind you that you always have to review very specifically when you operate in the specific country the respective law, and that you take in mind that there might be differences from country to country, and take care that you review those prior to cooperating with ATPs and prior to disclosing any private data.
Well, we're grateful for Ned, for your participation, for Ulf Grudman and Elizabeth Kutek for your kind contributions to this webinar. We like to thank the Core Data folks for helping to set this up, and also for kind of providing a vision for tracking this information. As we know, compliance is going global. It affects every piece of every company that's dealing in this area, and I just encourage you to read Policy in Medicine or subscribe to Life Science Compliance Update, our publication. We appreciate it. Thank you very much for attending, and we'll be sending out notices in the future. Thanks.